This homeowner parked his truck in his own driveway. His HOA fined him $100 for having a commercial vehicle, but the fines kept growing. Soon the HOA threatened to take his house. Now the case is in court.
Your Honor, I parked my truck in my own driveway. The HOA fined me $100 saying it was a commercial vehicle. Then they added late fees and legal fees and said they could foreclose on my home.
Your Honor, the community rules prohibit commercial vehicles in driveways. The homeowner ignored several warnings, so the HOA enforced the rules according to the bylaws. HOA associations have the authority to enforce rules, but those rules must be applied reasonably. Escalating a minor parking violation toward foreclosure is excessive. The court ruled that the foreclosure action could not proceed and the fines must be reviewed.
He sued his neighbor for $15,000, claiming a fence was stealing his land. But he didn't know the neighbor had a certified city survey that proved his swimming pool was actually the one trespassing. Watch the moment the judge drops the hammer.
Your Honor, this man built a fence 5 feet into my property. It's obstructing my view and devaluing my estate. I am seeking $15,000 in damages and the immediate removal of that illegal structure. The boundaries are clear.
I had a certified city survey done before I dug a single hole, Your Honor. Not only is my fence legal, but this survey proves that Mr. Henderson's custom swimming pool is actually sitting 3 feet onto my property.
Sir, you came here to take his money, but you've ended up losing your pool. This survey is legally binding. Lawsuit dismissed. I'm giving you 60 days to remove the encroachment from his land or he's authorized to fill it in.
An HOA board hired a crew to pump out a homeowner's green, dirty pool while he was on vacation. They claimed it was a mosquito hazard. They didn't realize what was swimming at the bottom.
Your Honor, the water was murky green and full of weeds. Our bylaws clearly state pools must be chemically treated in blue. It was a breeding ground for pests. We did the neighborhood a favor by draining that sludge. He should thank us for cleaning it up.
You didn't clean a pool, you destroyed a natural biopond. It's supposed to be green. That's the filtration system. When you drained it, you suffocated 15 grand champion Japanese koi. I've raised them for 20 years. Some are worth $15,000 each. They are all dead.
You entered private property and killed living creatures because the color offended your aesthetic preferences? Ignorance of biology is not a defense for destruction of property. You are liable for the replacement value of every single fish. Judgment for $225,000.
An HOA board hired a crew to gut a homeowner's front yard while he was out of town. They claimed it was nothing but dead plants and bugs. They didn't realize it was protected by the state.
Your Honor, we did him a favor. His yard was embarrassing. Dead plants, bugs everywhere, just sitting there rotting. We followed procedure. Notices, calls, the whole thing. He didn't respond, so we fixed it.
7 years. That's how long it took me to build what they ripped out in one afternoon. Those weren't weeds, they were native wildflowers protecting monarchs and bees. I had permits, I had certification, I had an award on my wall for it.
Let me be clear here. You had no authority to touch that yard. None. The law was on his side, the permits were on his side, the state was on his side, and your board decided none of that mattered. $180,000 to the plaintiff. Now get out.
A storm knocked a tree down overnight. Before cleanup crews could arrive, the HOA began issuing daily fines to the homeowner. No warning or time to respond. Now watch the judge's reaction to this timeline.
Your Honor, the storm hit late at night. By morning, the tree was already down across part of my yard. I called a cleanup service that same day, but they couldn't come out immediately because of the storm damage everywhere. Before anyone could remove it, I started getting daily fines.
The fallen tree constituted a safety hazard under association rules. Debris must be removed promptly. No temporary grace period applies after storms. Daily fines are applied automatically until the condition is corrected. No exception request was submitted.
Storm damage is not a voluntary condition. A homeowner is entitled to reasonable time to secure professional cleanup, especially after a widespread storm. Penalizing him while he is actively arranging removal is unreasonable. The fines are dismissed. Enforcement stops.
His house was the only one on the street that survived the tornado. The county fined him $22,000 for illegal structures inside the walls. But watch the moment the judge sees which building codes he followed.
I built this house myself in 1955. Back then, the standards were stricter. Double steel beams, reinforced corners, and a concrete foundation 3 feet deeper than the standard. After the tornado, my neighbors lost everything. My house stands without a single crack.
Now the inspector says that's exactly what makes it a violation.
Thermal imaging analysis revealed metal structures inside the walls that do not comply with the modern building code. Under County Ordinance 441, any non-standard structural elements require technical inspection and a permit. No permit was issued. The $22,000 fine was applied lawfully.
The 1955 building codes didn't just allow such structures, they required them. This house was built strictly according to the standards of its time. The law is not retroactive.
While the neighbors' homes lie in ruins, this house is still standing, precisely because of what you are fining him for. The fine is dismissed. The house is recognized as a model of construction. Court is adjourned.
He charged his neighbor a $20 toll every time she drove to her own garage. But he didn't check the 1920s title deed before he started his little business.
Your Honor, it's my concrete. That driveway sits on my property line.
If she wants the convenience of using my land to reach her garage, she needs to pay the maintenance fee. $20 is a bargain.
He told me it was a shared driveway, so I went to the county records office. Your Honor, this is the original 1920 title deed. There is no shared easement. This driveway belongs entirely to my property. He's been trespassing for 20 years.
Mr. Miller, you've been charging a toll on land you don't even own. That's not a business. That's extortion. You will refund every single dollar you took from this woman, plus interest. And if I see you standing in that driveway again, you're going to jail for trespassing. Case dismissed.
A city inspector showed up to a Marine's garage 11 times in 2 weeks, trying to find a violation. Every single time, he passed. Then the judge found out who was actually behind the complaints.
2 tours overseas, came home and started fixing bikes in my garage. 11 inspections in 2 weeks. Passed every single one. I'm not running a nuisance. I'm just, trying to make an honest living. Something felt wrong, so I started keeping records of everything.
The department responds to all filed complaints regardless of their origin. 11 inspections reflect the volume of concerns received, not any targeted intent. Each visit was, conducted professionally and by the book. The city cannot be held responsible for who chooses to file complaints.
11 complaints, all from the same competing shop owner 2 blocks away. The city became his personal harassment tool and didn't once question the pattern. That is not enforcement, that's retaliation. The Marine gets damages, and somebody needs to start screening these complaints.
ICE arrested a combat medic treating a veteran at the VA. The veteran was in crisis. They said he had a deportation order. This judge went nuclear.
We located him through VA records. The order was valid. We identified him. He was instructed to come with us. He refused, so we detained him.
Combat medic, 2 tours in Iraq. I work at the VA. That veteran was having a panic attack. PTSD episode. I was calming him down. They told me to step away. Another medic took over. He had to be sedated.
You arrested a combat medic treating a veteran in crisis. PTSD panic attack. He was talking him down. That veteran had to be sedated because you couldn't wait. Your order was from 2013. 12 years old. Hand over your badge.
A woman sold her husband's old purple car for $1,000 because she thought it was a junk project. She's about to find out she gave away their retirement.
It's been sitting on blocks for 5 years. It's loud, it smells like gasoline, and it was taking up space for my yoga studio. A nice man offered me $1,000 in cash, and I used it to buy a patio set. It's just an old Plymouth. He should be happy the driveway is finally...
Happy? That was a 1970 Hemi Cuda in plum crazy purple. It's one of the rarest muscle cars on the planet. You didn't clear the driveway. You sold a $450,000 museum piece for the price of a cheap sofa. That car was titled in my name only. It had no...
Ma'am, you cannot sell a title asset that you do not legally own. Furthermore, to the buyer, a $1,000 price tag for a vehicle of this magnitude is unconscionable.
The city called his bridge unsafe, then blocked the only road to his home, ignoring his request for inspection and leaving a sick woman with no way to get emergency help. What the judge said next shocked the entire courtroom.
Your Honor, that bridge is the only way in and out of our home. When they blocked it, no car could reach us. No doctor, no ambulance, nobody. My wife is recovering from a serious illness. She needs regular medical visits to stay well. When you blocked that bridge, you didn't block wood and nails. You blocked the only way help could reach us.
Your Honor, the bridge failed to meet current safety standards and posed a liability risk to the public. The department was obligated to restrict access until proper approval was obtained. We were not informed that emergency access would be affected by this decision. The department followed protocol. We did not intend to leave anyone without access.
He wrote to your department asking for help, but you ignored him. Then you blocked his only road out and called it procedure? Calling something unsafe does not give any authority the right to leave citizens completely cut off.
The city will remove all barriers immediately, fund full bridge repairs, and respond to every pending request from this homeowner.
The county shut off his water over a 12 billing error he already paid. 4 months without running water. 3 kids in the house. Then the judge found something they didn't expect.
Your Honor, the county shut off my water over a $12 billing error. I paid it the same day. They never turned it back on. 4 months. My 3 kids had no running water. We bathed at my neighbor's. I called 17 times. Every time they said a reconnection order was being processed. 4 months. Nothing.
Your Honor, the disconnection was issued for a past due balance under county utility code. Standard procedure was followed. The reconnection request was delayed due to a system processing backlog. The county regrets the inconvenience.
Mr. Finn, you shut off his water over $12. He paid that day. Why is it still off?
The reconnection order was entered into the system, Your Honor. Processing times vary by district.
Processing times. I'm opening his payment receipt. Paid March 14th. Water still off July 18th. 4 months.
3 children without running water because your office can't process a reconnection for a bill that was paid.
paid.
Water on today, county pays $60,000. You don't leave children without water over $12.
His front yard had been untouched for decades. Then a utility crew installed equipment without warning. When he objected, they claimed an easement. Now watch the judge's reaction to this missing paperwork.
Your Honor, I came home and found a utility box placed on my lawn. No letter, no phone call. I checked my property documents. There's no easement listed in that location. The equipment stayed there for 3 weeks. Technicians came and went. It's my front yard. I was never asked.
Your Honor, the equipment was installed to stabilize service in the area. Crews acted under the belief that a utility easement applied. The placement was temporary, pending infrastructure adjustments. The company did not intend permanent occupation. Operations were conducted in good faith.
Utility access must be supported by a valid easement or express consent. Good faith does not substitute for documented authority. Temporary placement does not eliminate property rights. The record does not establish a lawful easement at the location used. The equipment shall be removed. The homeowner is entitled to compensation for temporary occupation and lawn restoration costs. Future access must comply with documented boundaries. You may proceed.
Ray Kowalski spent 28 years on the floor at Kellerton Steel. The day he retired, his pension was $2,340 a month. A year later, the company cut it by 30%. Watch what this judge says.
Your Honor, under Section 7.4 of the Kellerton Retirement Plan, the company retains the right to amend benefit schedules due to actuarial shortfalls. This adjustment was communicated in writing to all affected retirees. Notice was sent via certified mail.
I got a letter. I didn't understand half of it. It said something about actuarial adjustments. I called HR 3 times and nobody told me they were cutting what I was already receiving.
Mr. Kowalski's failure to contest within the 60-day window constitutes acceptance under the plan.
I already retired. I sold my truck. I planned my whole life around that number. I'm 66 years old. I can't just go back to work.
The plan document Mr. Kowalski signed at retirement specifies a fixed monthly benefit of $2,340. There is no reduction clause for benefits in pay status. Under 29 U.S.C. Section 1054, subsection G, the ERISA anti-cutback rule, a plan sponsor cannot reduce accrued benefits through amendment once payments have commenced. Courtroom Manufacturing is ordered to restore the full benefit and remit all withheld amounts with interest within 30 days. Counsel, I review your other retiree files because this will not be the only courtroom you visit.
An HOA is fining a man $50 a day because he didn't take his Christmas lights down by the January 5th deadline. Watch the judge react when the homeowner proves he was in the ICU during the violation period and the HOA refused to grant a medical extension.
I was hospitalized for an emergency heart procedure on January 3rd and didn't get home until the 10th. I called the board from my hospital bed to explain the situation, but they told me rules are rules and started the fines anyway.
Our bylaws are designed to maintain a uniform neighborhood appearance, and the January 5th deadline is applied equally to every resident. If we begin making subjective exceptions for personal circumstances, we lose the ability to enforce the community standards that protect everyone's property values.
The purpose of an HOA is to manage a community, not to abandon basic human compassion during a documented medical crisis. I am vacating these fines in their entirety and ordering the association to pay for the defendant's legal fees for this unnecessary hearing. Case dismissed.
Subscribe to support the channel.